Good afternoon and welcome. Let's get right into it. Okay, so we stopped last class at page 6. So let's go there now. All right, and let's take off where let's resume where we left off. Okay. So we are right there right now. Yes, indeed. Okay.
Main Volume. Chapter 22, Defamation. Section 1. Generally. Subsection, C, Reform, Defamation Act 1996 and Civil Procedure Rules 1998. Subsection, I, Defamation Act 1996. The Defamation Act 1996. 22-05. The Defamation Act 1996 contains provisions aimed at reforming and improving the law and practice of defamation. Its principal provisions are: a statutory defense available to distributors, printers, and others provided that they neither knew nor had reason to believe that their acts contributed to the publication of defamatory material, S.1 and C. Para. 22-182. b. SS 2-4 of the Act provide for a defense of offer of amends which differs significantly from the former offer of amends regime under S.4 of the Defamation Act 1952. c. A summary procedure for disposal of claims in defamation claims. SS 8, 9, and 10. d. One of the most controversial provisions in the Act is contained in S.13, whereby the effect of Art.9 of the Bill of Rights 1688 was modified in that a member of either House of Parliament may waive the effect of Art.9 insofar as it affects him or her, and may therefore allow matters which have occurred in parliamentary proceedings to be raised in court, see Para. 22-97. the reduction of the limitation period for defamation actions to 1 year. In several cases, the courts have now considered the implications of the offer of.
Okay, so we're pausing here for a bit. Let's take a look. Okay, so let me just read out how that sentence ends. In several cases, the courts have now considered the implications of the offer of amends procedure under Section 2(4) of the Defamation Act 1996, in particular, the assessment of damages in such cases. Okay.
Clerk and Linsell on Torts 20th ed. Main Volume. Chapter 22, Defamation. Section 1. Generally. Subsection C. Reform, Defamation Act 1996 and Civil Procedure Rules 1998. Subsection 2. Civil Procedure Rules 1998. The Civil Procedure Rules 1998. 22-06. Further effects on defamation proceedings resulted from the introduction in April 1999 of the Civil Procedure Rules 1998 and accompanying practice directions, as a result of the Wolf Report on Civil Justice. In addition to the provisions specifically concerned with defamation, namely CPRPT 53 and the accompanying practice direction, civil litigation, including defamation litigation, is now governed by the overriding objective of the CPR. This includes, so far as is practicable, ensuring that the parties are on an equal footing, saving expense dealing with the case in ways which are proportionate to the amount of money involved, the importance of the case, the complexity of the issues and the financial position of the parties, ensuring that the case is dealt with expeditiously and fairly, and allotting to it an appropriate share of the court's resources. In McPhilmy v. Times Newspapers Ltd. 17, Lord Wolf in the Court of Appeal foresaw the potential of these principles to affect the extent and complexity of defamation proceedings with a view to streamlining such litigation. The effect of the CPR has been seen in numerous subsequent cases, and the provisions for summary judgment under PT 24 of the CPR have been particularly effective at weeding out weak cases prior to trial. 18. Impact of the rules. 22-07. In making decisions in the course of defamation litigation, e.g. deciding whether to strike out a case, the judge has a duty under the CPR to take a realistic practical attitude and to act in accordance with the overriding objective. 19. The Law Commission, in its examination of Defamation Procedure 20, found that the civil procedure rules have had the effect of stamping out the practice of claimants in defamation sending gagging letters before action and issuing gagging writs before the commencement of proceedings.
Okay. All right, this is important. Let's see, in making decisions in the course of defamation litigation, deciding whether to strike out, the judge has a duty on the CPR to take a realistic, practical attitude and to act in accordance with the overriding objective. The Law Commission, in its examination of defamation procedure, found that the civil procedure rules have had the effect of stamping out the practice of claimants in defamation sending gagging letters before action and issuing gagging writs before the commencement of proceedings. So this was something this is something many attempt. They still seek to send these gagging letters. Okay, so let us now move on. Okay. Move on now to the next page, main volume.
The claimant sued the defendant, an internet service provider, ISP, for libel in respect of an article, purporting to be written by the claimant and defamatory of him, which had appeared on the internet through the defendant's forum. The claimant faxed the defendant's managing director to complain that the article defamed him and to ask for its removal, but this was not done and it remained on the internet for 2 weeks. On an application by the defendants to strike out the claimant's case, the court held that the defendant company was not a publisher within the meaning of S.1 of the Defamation Act 1996. However, the court held that the defendants were not entitled to the protection of the innocent dissemination defense under the section, having been put on notice that the allegations were defamatory and failed to take them off the website. In Metropolitan International Schools Ltd v Design Technica Corp 22, it was decided that the search engine Google cannot be regarded as a publisher of defamatory material appearing on a search return, since there is no human input from the company's officers when a search is carried out. In a number of cases, 23 parties have applied successfully for orders requiring website hosts to disclose the source of defamatory material which had been posted anonymously on their websites. The Internet frequently gives rise to jurisdictional issues also. In King v. Lewis 24, the claimant was allowed to sue in England as the defamatory material on the Internet was downloaded in England. The claimant also had a reputation in the UK. Point 25. The Electronic Commerce, EC Directive, Regulations. 2002, SI 2002/2013, implement the European E-Commerce Directive, under which an intermediary such as an internet service provider who is a mere conduit of information may not be liable for defamatory material posted on its website even if put Page 9. On notice of the defamatory statement, subject to certain conditions. The directive also limits the liability of ISPs which cache information and where the ISP hosts the website for a third party. Point 26. Single Publication Rule 22-09. In Lauczynski v. Times Newspapers, No. 2, 27, the Appellant's Counsel argued that the rule of the common law, which establishes that every publication of a libel gives rise to an action for defamation, should be changed by the court so as to accord with the realities of Internet communication. The Court of Appeal refused to change the law, confirming the single publication rule laid down in the case of Duke of Brunswick and Lundberg v. Harmer. Point 28. The decision was upheld by the European Court of Human Rights in Times Newspapers Ltd v. the United Kingdom. Point 29. The single publication rule has also been reaffirmed in Dow Jones & Co. Inc. v. Jamil. Point 30. The Court of Appeal rejected a contention that the rule contravened Art. Point 10. The right to freedom of expression. However, the Court of Appeal went on to strike out the claim as an abuse of process. Publication was to 5 persons, 3 of whom could be ascertained were members of the claimant's camp, his solicitor and other advisors or aides. The court did not consider that publication to 2 third-party individuals constituted a sufficiently substantial tort to warrant the expense and court resources of a full-scale defamation action. 21 2001 QB 201. 22 2009 EWHC 1765, QB, 2009 EMLR 27. 23. A court order is often required because the ISPs have to act in accordance with the rights under the Data Protection Act 1998 of individuals subscribing to their services and/or because the contract between the ISP and the publisher guarantees the publisher's anonymity. CEG Totaliza v Motley Fool 2001 EWCA Civ 1897, 2002 1 WLR 1233, Sheffield Wednesday Football Club Ltd v Hargreaves 2007 EWHC 2375, QB, Smith v Adv plc 2008 EWCA Civ 518. In such cases it is often the case that the applicant has to pay the costs of the respondent irrespective of the outcome. 24 2004 EWCA Civ 1329, 2005 EMLR4. 25 See also Richardson v Schwarzenegger 2004 EWHC 2422, QB. 26 See also Bunt v Tilley 2006 EWHC 407, QB, 2007 1 WLR 1243, 2006 3 All ER 330. Defamation. Section 1. Generally. Subsection E. Human Rights Act. Conflict between free speech and reputation. 22-10. The conflict between the values of freedom of speech on the one hand and the protection of a person's right to his reputation on the other has been addressed by the English courts, especially in the context of Art. 10 of the European Convention on Human Rights, which provides for freedom of speech subject only to restrictions which are necessary. The conflict between the values of freedom of speech on the one hand and the protection of a person's right to his reputation on the other has been addressed by the English courts, especially in the context of Art. 10 of the European Convention on Human Rights, which provides for freedom of speech subject only to restrictions which are necessary. So in Derbyshire CCV Times Newspapers 31, the Court of Appeal referred to Art. 10 in reaching their decision that a local authority cannot sue in defamation in relation to its governing reputation, since to allow such an action would be to permit a fetter on freedom of speech. The Court of Appeal held unanimously that the European Convention should be consulted for assistance where there was ambiguity in legislation, where a discretion was to be exercised or where the law was uncertain. Balcom L.J. and Butler Sloss L.J. were also prepared to consider Art. 10 even if the common law was certain, to avoid conflict between English law and the Convention. The House of Lords, however, based its decision on the common law which it regarded as consistent with Art. 10. In the cases of Ranson v. Mirror Newspapers 32, John v. MGN 33 and Reynolds v. Times Newspapers 34, Art. 10 was again considered and applied or declared to be compatible with the common law. In Tolstoy Miloslavsky v. United Kingdom 35, the applicant to the European Court of Human Rights claimed successfully that the award of £1.5 million against him in a libel action was excessive and constituted a breach of Art. 10 as being an undue restraint on freedom of speech. 36 The media have launched a series of attacks on the defamation laws on the base of interference with free speech, however with limited success. 37. The Human Rights Act 1998. 22-11. The Human Rights Act gives effect to the rights and freedoms guaranteed under the European Convention on Human Rights in the Courts of the United Kingdom. Section 6 of the Human Rights Act makes it unlawful for a public authority to act in a way incompatible with one or more of the rights laid down in the Convention. Public authorities here includes courts and tribunals and, to the extent that they are exercising public functions, companies responsible for areas of activity which were previously within the public sector. The approach of the Act is to provide those alleging a breach of the Convention with a remedy for that breach in the domestic courts of the United Kingdom. Sections 7 and 8 of the Act provide that persons who have been victims of such actions may bring proceedings in which the court may grant such relief or remedy, including damages, as is just and appropriate. In several earlier cases the English courts based their decisions rather on common law and general principles than On the Human Rights Act. 38 However, since the Human Rights Act 1998 came into effect, they refer to the European Convention and decisions of the European Court of Human Rights in relation to Art 6 and 8 and especially Art. 10. 22-12. The importance of freedom of speech under Art. 10 of the European Convention, since the Human Rights Act 1998, has also been stressed in cases involving media reports of the conduct of celebrities, not only in defamation but also in cases where prominent people have sought to prevent publication of true details about their lives and conduct by injunction or, after the event, by claims for damages. The House of Lords confirmed. Page 11. In Wainwright v. Home Office 39 that English common law knows no tort of invasion of privacy, but developments in the law of confidence, coupled with Art. 8 of the European Convention, which protects the right to respect for private and family life, seem to have achieved a level of protection of personal information in the case of statements which are true, but nevertheless damaging. 40 In W v Westminster CC 41 a defamation claim against the local authority and 2 of its employees failed, on the grounds that the allegations made were covered by qualified privilege. Nevertheless, the trial judge found that the making of untrue allegations of pedophilia about the claimant by a local authority constituted an infringement of the claimant's rights under Art. 8 of the Convention. The judge invited submissions on whether a claim might be brought under S.7 of the Human Rights Act 1998 and went on to find that the claim was well-founded, and made a declaration to that effect. The judge did not award damages, although he accepted that damages could be available for such a claim. Article 6. 22-13. This article of the Convention, which provides for the right to a fair trial, is often cited by parties in relation to defamation actions, for example by claimants to challenge the striking out of their claims or by defendants to dispute the issue of injunctions. Further, on this ground, either party might dispute the denial of jury trial. A successful application to the European Court of Human Rights was made by the defendants in the McDonald's litigation in connection with the unavailability of legal aid in relation to their defense of a defamation claim brought by McDonald's plc. 42 In applying the complex principles of defamation, e.g. in deciding whether or not to strike out a case or in adopting summary procedure under SS 8-9, the courts must bear in mind their duty under Art. 6 to provide the parties with a fair trial. It has even been suggested that where a claimant is funded by a conditional fee agreement, CFA, and has no after the event 8. Insurance, so that the defendant who loses the case will have to bear the costs, including uplift fees of 100%, or the defendant is subject to a chilling effect which could jeopardize the defendant's chance of a fair trial. 43. Article 8. 22-14. This article, which states that everyone has the right to respect for his private and family life, his home, and his correspondence, has been used by the courts to build up a body of case law protecting privacy. It has become increasingly important in relation to litigation by claimants complaining of revelations in the media relating to their private lives. Although the case of Wainwright v. Home Office 44 decided that there is no tort of breach of privacy in English law, several claimants have successfully invoked Art. 8, often in conjunction with the law relating to breach of confidence, e.g. to sue defendants who publish unauthorized photographs of the claimant's wedding, Douglas v. Hello Ltd., 45, or details of their private lives, Campbell v. MGN, .46.
Okay, we're going to do that sentence again.
Point 8. If they fail to protect the right to privacy. This article, which states that everyone has the right to respect for his private and family life, his home, and his correspondence, has been used by the courts to build up a body of case law protecting privacy. It has become increasingly important in relation to litigation by claimants complaining of revelations in the media relating to their private lives. Although the case of Wainwright v. Home Office 44 decided that there is no tort of breach of privacy in English law, several claimants have successfully invoked Art. 8, often in conjunction with the law relating to breach of confidence, e.g. to sue defendants who publish unauthorized photographs of the claimant's wedding, Douglas v. Hello. Ltd., 45 or details of their private lives, Campbell v. MGN, point 46. Since the courts are public authorities, persons aggrieved maintain that they are in breach of Art. 8 if they fail to protect the right to privacy. This creates a conflict between the rights of the claimant under Art. 8 and the media's right to freedom of expression under Art. 10, see below. In such cases, the courts are required to conduct a balancing exercise in determining which of the competing rights should prevail. Point 47. In Clift v. Slough Borough Council 2010 EWCA Civ 1171, 2011 3 All ER 118, the Court of Appeal accepted that the act of a local authority in including a person on its violent persons register and emailing that information to various other departments was disproportionate and in breach of the individual's rights under Art. 8 of the Convention. As a result, the local authority did not therefore have a defense of qualified privilege. The Court of Appeal recognized that the right to reputation is an aspect of the right to a page 12. Private life protected under Art. 8, and that in cases involving public authorities, following the enactment of the Human Rights Act 1998, defenses such as qualified privilege could only be applied in compliance with the Art. 8 right under the Convention. Article 10. 22-15. This article provides for freedom of speech and is a vital issue in defamation cases. The approach of the English courts in several cases before the 1998 Act suggests that they will be robust in striving to defend the right of freedom of speech and is a vital issue in defamation cases. The approach of the English courts in several cases this article provides for freedom of speech and is a vital issue in defamation cases. The approach of the English courts in several cases before the 1998 Act suggests that they will be robust in striving to defend the right of freedom of speech. However, it seems unlikely that they will develop a separate approach to statements about public figures. Some commentators have suggested that the principle in New York Times v. Sullivan 48 might be adopted here in order to protect the right of the media to criticize public bodies or famous individuals. In Sullivan, the Supreme Court of the United States held that public officials cannot sue for defamation unless the claimant can show actual malice on the part of the defendant. The Neal Committee expressly disapproved the introduction of the Sullivan Rule into English law, and no English court has yet accorded it approval. The House of Lords considered the important issue of press freedom in relation to matters of public interest in Reynolds v. Times Newspapers Ltd. 49, where the House refused to recognize a new category of qualified privilege while accepting the validity and importance of legitimate political comment. Following the coming into force of the Human Rights Act in October 2000, in applying Art. 10 under the Act, English courts have been called upon to reconcile the right to freedom of speech with the right to privacy under Art. 8, particularly in cases involving the media and its coverage of the conduct or reputation of public figures. In MGN Ltd v United Kingdom, App No 39401/04, 2011, 53 EHRR 5, the European Court of Human Rights was asked to consider whether the imposition of a 100% uplift on the costs claimed by Naomi Campbell's lawyers following her win in her privacy case against MGN in the House of Lords was compatible with Art. 10 of the Convention. The uplift was a success fee claimed by the lawyers because they had represented Ms. Campbell on a no-win, no-fee, or conditional fee basis. The court ruled unanimously that the imposition of a success fee at 100%, i.e. double the base costs, was incompatible with Art. 10, being a disproportionate infringement of the newspaper's right to freedom of expression. The case confirmed the view of the committee set up by Lord Justice Jackson to review costs in media publication cases that success fees at 100% should play no part in such disputes, and heralds the end of the conditional fee regime in its current form. The regime is due to be the subject of new rules of court concerning the funding of such cases, which are due to come into force within the next year. Clerk and Linsell on Torts, 20th ed. Main Volume. Chapter 22, Defamation. Section 2. Basis of liability. Libel and slander. Page 14. 22 to 16. Defamation consists of two torts: libel and slander. 50 Defamation in transitory form is usually slander, whereas defamation in permanent form is libel. Libel generally indicates something printed or written, but it includes also anything in a more or less permanent form. 51 Such as a painting or picture. 52 Effigy. 53 Caricature. 54 Advertisement. 55 Talking film. 56 Or any disparaging object. 57 Reading out a defamatory document to a third party is the publication of a libel. 58 Dictating defamatory matter to a typist is clearly slander. 59 But if the dictated matter is turned into a letter and published to a third party, the dictator may be liable for the publication of a libel through his agent. 60 As regards matter recorded on a record, tape, or some other recording instrument, it is submitted that the publication of the recorded matter would be a publication in permanent form, i.e. libel. 61 Section 166 of the Broadcasting Act 1990 provides that the publication of words in the course of any program, including a program service, shall be treated as publication in permanent form. This provision replaces S.1 of the Defamation Act 1952, which is repealed in SCH.21 to the 1990 Act. Broadcasts within S.1 of the 1952 Act applied only to publication for general reception, and other broadcasts were outside the statute and subject to common law. Section 166 of the 1990 Act is not so limited and applies to any program included in a program service. CSS 201 and 202. 62 The Theatres Act 1968 provided that the publication of words in the course of a performance of a play, other than certain performances accepted by S.7 of the Act, is to be treated as publication in permanent form. 57 Reading out a defamatory document to a third party is the falsehood and malice. 22 to 17. The publication of defamatory matter with reference to the claimant will give rise to a cause of action in defamation. The claimant must in his statement of case be able to set out with reasonable certainty the alleged defamatory words, 64 their alleged meaning, and, if necessary, factors relied upon as identifying the claimant as the subject of the allegations. The claimant need not allege that the imputation published is false or that it has been published maliciously. Since it is not to be assumed that anyone is of bad character, defamation of an individual is taken to be false until it is proved to be true. Malice only becomes relevant if the defendant seeks to rely on a defense which may be defeated on proof of malice, such as qualified privilege. 65 It may also be relevant to any claim for aggravated or exemplary damages. 66 Motive immaterial.
Okay, we're going to go over that again. Okay.
22 to 18. 22 to 18. The pub 22 falsehood and malice.
Okay, we're going over falsehood and malice. Please take note.
Malice. 22 to 17. The publication of defamatory matter with reference to the claimant will give rise to a cause of action in defamation. The claimant must in his statement of case be able to set out with reasonable certainty the alleged defamatory words, 64 their alleged meaning, and, if necessary, factors relied upon as identifying the claimant as the subject of the allegations. The claimant need not allege that the imputation published is false or that it has been published maliciously. Since it is not to be assumed that anyone is of bad character, defamation of an individual is taken to be false until it is proved to be true. Malice only becomes relevant if the defendant seeks to rely on a defense which may be defeated on proof of malice, such as qualified privilege. 65 It may also be relevant to any claim for aggravated or exemplary damages.
Okay. One more time. One more time. Falsehood and malice. The publication of defamatory matter with reference to the claimant will give rise to a cause of action in defamation. The claimant must, in his statement of case, be able to set out with reasonable certainty the alleged defamatory words, the alleged meaning, and if necessary, factors relied upon as identifying the claimant as the subject of the allegations. The claimant need not allege that the imputation published is false or that it has been published maliciously, since it is not to be assumed that anyone is of bad character. Defamation of an individual is taken to be false until it is proved to be true. Malice only becomes relevant if the defendant seeks to rely on a defense which may be defeated on proof of malice, such as qualified privilege. It may also be relevant to any claim for aggravated or exemplary damage. Okay, so this is what are the issues here? Claimant must in a statement certainty, okay, this has not happened, the alleged meaning, and if necessary, factors relied upon as identifying claimant. Okay. Do we want to take this piece down? Do we want to take this piece down?
Damages point 66. Motive
Let's move on.
immaterial. 22 to 18. Except where the occasion is one of qualified privilege, the motive of the defendant is immaterial in determining his liability. A man may be the publisher of a libel without a particle of malice or improper motive. 67. If a defendant has published what he knew, or ought to have known, was calculated to injure the claimant, he must be responsible for the consequences, though his object might have been to injure another person than the claimant, or though he may have written in levity only. No one can cast about firebrands and death and then escape from being responsible by saying that he was in sport. 68. He cannot defend himself by showing that he intended in his own breast not to defame, or that he intended not to defame the claimant, if in fact he did both. 69. If, therefore, the defamatory matter would reasonably 70 be understood by members of the public who knew the claimant to refer to him, the defendant is liable, even though he may prove that the words, when written, were not and could not have been intended to. Page 15. Apply to the claimant, and indeed, that he was not aware and had no reason to be aware of the claimant's existence. Point 71. It is for the publisher of the statement to describe the person he intends to refer to with sufficient clarity to ensure that no reasonable person would think the statement applied to anybody else. Point 72. An important modification of the liability to pay damages in certain cases of unintentional defamation published without negligence was introduced by S.4 of the Defamation Act 1952, which provided a procedure in cases where words were published innocently within the meaning of the section. This section has been repealed and replaced by a new defense under SS2-4 of the Defamation Act 1996, see para. Point 22-181. Considerations relating to the lack of intention to defame may also properly be put forward in relation to mitigation of damages. Point 73. Defamatory meaning. 22 to 19. On the question of whether the words complained of have a defamatory meaning, liability is based on an objective test. What would the words reasonably be understood to mean in the light of the surrounding circumstances as known to the person to whom they were published? 74. A defendant may be liable for words innocent on the face of them which are in fact defamatory of another person by reason of facts unknown to the author or publisher but known to the person to whom they are published. Point 75. Similarly, a defendant may be liable for a defamatory statement that can reasonably be taken as referring to the claimant by persons with special knowledge, even though the defendant neither had nor could have had any knowledge of the facts that caused those persons with special knowledge to connect the claimant with the statement. Point 76. This is commonly referred to as an innuendo meaning. Reference to the claimant. 22 to 20. The claimant must prove that he is referred to, but he may have been referred to by initial 77 or by asterisk 78 or by a fictitious name 79 or the name of somebody else 80 or by reasonable inference from a statement concerning another person 81 or by a statement true of another person which might reasonably be understood as referring to him. 82 The fact that the claimant has a common name is not sufficient of itself to negate reference to him. 83 The question whether the defamatory words refer to the claimant is determined by an objective test, and liability arises if the words are in fact defamatory of the claimant whether or not there has been an intention to refer to him, or negligence in relation to reference to him. 84 If those who look on know well who is aimed at, the very same injury is inflicted, the very same thing is in fact done, as would be done if his name and Christian name were 10 times repeated. 85 Evidence is admissible to prove that persons with special knowledge understood the claimant to be referred to in any of the above situations. 86 There is no rule that for a statement to be defamatory of the claimant it must contain some key or pointer 87 indicating him or her. It is sufficient if a sensible person in the light of any special facts or knowledge proved, could reasonably have understood that the statement referred to the claimant. 88 The circumstances in which the statement was published will be relevant in ascertaining whether an inference that the claimant was referred to was reasonable. A person is not expected to read the daily newspaper with the same care as that of a businessman scrutinizing a contract. 89 It is for the judge to decide whether the words complained of are capable of being taken as referring to the claimant, and a question of fact for the jury whether they were reasonably so understood. 90 Where the defamatory words do not clearly refer to the claimant, i.e. by name, the defendant is entitled to particulars of the material facts on which the claimant relies in support of his allegation that he has been referred to. 91 For example, evidence of statements by spectators looking at a libel louse picture and of page 16. Telephone communications to the claimant are admissible to show that the words complained of related to the claimant. 92
Okay, all right. We are going to resume now to look alike images. In Kerry O'Shea, the claimant sued the defendants in respect of a pornographic advertisement for an internet service provider published in 5 consecutive issues of their newspaper. The advertisement contained a picture of a woman who was the lookalike or spitting image of the claimant, but who was in fact a glamour model. The claimant adduced evidence to the effect that family members and a friend had reasonably understood the photograph to be of her and had therefore believed that she was involved in the website in question. Morland J. stated that he was unable to conclude that the jury could not have reasonably decided that the defamation referred to the claimant, and he had then to consider whether this case of unintentional defamation was an impermissible restriction of freedom of expression under Article 10. Clearly, the strict liability incurred by an unintentional defamer is such a restriction. The question then arises, is it necessary for the protection of others? Quoting Lord. So this part here is about lookalike images. So it can go either way. Quoting it depends on the judge. Quoting Lord Keith of Kinker in Derbyshire, CCV Times newspapers. The judge described the meaning of necessary here as required by a pressing social need, and bearing in mind that the restrictions should be no more than is proportionate to the legitimate aim of the society to which they belong. The judge observed that photographs are an essential adjunct of journalistic articles, and it would be an unwarranted burden on an editor to be expected to check if a picture of one person resembles someone else would be defamed by the publication. If such a publication were made maliciously, the tort of malicious falsehood would provide a remedy, but in the present circumstances, to extend a strict liability for unintentional defamation to the publication of a lookalike picture which accidentally defamed someone would be a breach of Article 10 of the European Convention. Okay, so let's move on.
Look-alike images. 20. In Karioshe v. MG, defamation of a class. 22 to 22. The question whether an individual can sue in respect of words which are directed against a group, or body, or class of persons generally, was considered by the House of Lords in Knupfer v. London Express newspaper Ltd 94, and the law may be summarized as follows. A. The crucial question remains whether or not the words are reasonably capable of referring to the claimant. What matters is whether the words were published of the claimant in the sense that he can be said to be personally pointed at 95 rather than the application of any arbitrary general rule subject to exceptions that liability cannot arise from words published of a class. In Orm v. Associated Newspapers Group Ltd 96, it was held that as it was widely known that the claimant was the leader of the Unification Church, the Munas, in England, defamatory allegations against that organization would be reasonably identified with the claimant personally by readers of the defendant newspaper. At the very least, people would think that Mr. Orm must have known of the alleged malpractices and so be part of them. B. Normally, where the defamatory statement is directed to a class of persons, no individual belonging to the class is entitled to say that the words were written or spoken of himself. No doubt, it is true to say that a class cannot be defamed as a class, nor can an individual be defamed by a general reference to the class to which he belongs. 97. As Wiles J. said in Eastwood v. Holmes, if a man wrote that all lawyers were thieves, no particular lawyer, page 17, could sue him unless there was something to point to the particular individual. 98. C. Words which appear to apply to a class may be actionable if there is something in the words, or the circumstances under which they were published, which indicates a particular claimant or claimants. 99. D. Again, if the reference is to a limited class or group, for example trustees, members of a firm, tenants of a particular building, so that the words can be said to refer to each member, all will be able to sue. 100. E. Whether there is evidence on which the words can be regarded as capable of referring to the claimant is a matter of law for the judge. If there is such evidence, then it is a question of fact whether the words lead reasonable people who know the claimant to the conclusion that they do refer to him. In Knupfer, the claimant was the representative of the British branch of the Young Russia Party. There were 2,000 members of the party, with 24 members in Britain. A British newspaper accused the party of being pro-Hitler, but there was no reference to any particular member in the article.
Okay, we're going to look at that again in Knupfer. Okay, we're taking it from here. Let's try that.
Misconduct against Banbury Sid. In Knupfer, the claimant was the representative of the British branch of the Young Russia Party. There were 2,000 members of the party, with 24 members in Britain. A British newspaper accused the party of being pro-Hitler, but there was no reference to any particular member in the article. The House of Lords upheld the Court of Appeal's decision that the article was not capable of referring to the claimant, as distinct from the party as a whole. In contrast is Riches v. News Group Newspapers 101, in which the News of the World made various allegations of misconduct against Banbury Sid, naming only one officer. There were 12 officers who made up Banbury Sid, 10 of whom sued for libel. They succeeded in showing that the allegations would have been understood to refer to them. 50 CK, Libel and Slander, 2 torts or 1. 1975, 91 LQR 524. Malicious falsehood is often discussed as a species of defamation also. 51 C. Broadcasting Act 1990 S.166,
Okay.
1. and Kazire v. Australian Broadcasting
when we
Commission
skip this part,
1964 vr 702. 52 Du Bost v. Beresford, 1810, 53 Mont, 54 Dunlop, 55 Tully, 56 Yusuk, 57 E.G. Gallows at the Claimant's Door, 5 Republic 125 at 125b, Car v. Hood, 1808, 1 Camp. 355N, Air v. Garlic, 1878, 42 JP 68. In Jeffreys v. Duncombe, 1809, 11 East. 237, the claimant recovered damages against the defendant for keeping in front of the claimant's house a lamp burning during the daytime, thereby intending to mark out the dwelling of the claimant as a bawdy house. The action is described in the report as one of nuisance. It would seem in substance an action of libel. 58 Forrester v. Tyrrell, 1839, 9 TLR 257.
okay, let's see, we may be pausing here. We may be pausing here. Let's take a look at what's next. Let's take a look. Okay. Let's take a look. Let's see. What's next? All right, the test. Okay, so that's what's next. All right, the test. This test is to know if something is defamatory. Okay, so we'll take it from there. So you can read ahead. Chapter 22, Defamation, Clark and Lindsay. Take it from, this is the 20th edition. Take it from section 3, what is defamatory? Subsection A, the test. Okay, so until next week, we are signing off for now. And enjoy, sorry, not next week. We're going to be back again tomorrow with another class. Okay, so until the next class, read up on the test. That would be pages 19, from page 19 onward. Okay, so let us close off now. So enjoy the rest of your evening or morning, as the case may be, and we'll see you again next class. All right. So let us close off. All right. Let us close off right now.